Let us continue. Now, we have wage distortion disputes in unorganized establishments not voluntarily settled by the parties pursuant to Republic Act Number 6727, and the enforcement of compromise agreements when there is non-compliance by any of the parties pursuant to Article 227 of the Labor Code as amended. So, moving on. Money claims arising out of employee-employee relationships or by virtue of law or contract involving Filipino workers for overseas deployment, including claims for actual moral, exemplary, and other forms of damages, as provided by Section 10 of RA 8042 as amended by Republic Act 10022. So, kasama dito ang POEA and DOA. Next, the other cases as may be provided by law. Now, if you'll ask how complaints are filed, the party initiating the action is called complainant or petitioner, and the opposing part is the respondent. The full names of all the real parties in interest, whether natural or juridical persons or entities authorized by law, shall be stated in the caption of the complaint or petition, as well as decisions, resolutions, or orders. Within 2 days from receipt of the case, the Labor Arbiter shall issue the required summons, attaching thereto a copy of the complaint, petition, and supporting documents, if any. The summons, together with a copy of the complaint, shall specify the date, time, and place of the conciliation and mediation conference in 2 settings. Why is there a need or a purpose of mandatory conciliation and mediation conference? Activate your photographic memory. We have amicably settling the case upon a fair compromise, determining real parties and interests. Done with photographic memory, we now proceed. Determining the necessity of amending the complaint and including all causes of action. Defining and simplifying the issues in the case. Entering into admissions or stipulations of facts. And threshing out all other preliminary matters. Now, what is the effect of non-appearance of the parties in the mandatory conciliation and mediation conference? So, paano ba pag hindi umappear ang mga parties sa mediation and conciliation? Ganito lang yon. The complainant or petitioner ang naghabla during the 2 settings for mandatory conciliation and mediation conference scheduled in the summons, di sila dumating sa loob ng 2 beses. Despite due notice, there shall be a ground for the dismissal of the case without prejudice. So, mari-dismiss ang case. Now, in the non-appearance naman ni respondent during the first scheduled conference, the second conference scheduled in the summons shall proceed. So, tutuloy ang kalawang conference. If the respondent still fails to appear at the second conference, despite due notice and summons, sinasabi niya he has waived his or her right to file a position paper. Now, this Labor Arbiter shall immediately terminate the mandatory conciliation and mediation conference and direct the complainant or petitioner to file a verified position paper and submit evidence in support of his or her causes of action, and thereupon render his or her decision on the basis of the evidence on record. So, tandaan, 2 beses na non-appearance, madidismiss ang case kapag complainant. Now, for the respondent, nabibigay na niya right for the position paper. The Labor Arbiter will now, based on the position paper, will give decision based on the evidence he has on hand. Okay, remember that. Now, for arbitration, the Labor Arbiter shall take full control and personally conduct the hearing or clarificatory conference. Now, during the arbitration proper na to, siya ang may karapatan, siya ang maghuhusga, and may ask questions for the purpose of clarifying points of law or facts involved in the case. Now, the labor arbiter may allow the presentation of testimonial evidence with the right of cross-examination by opposing party and shall limit the presentation of evidence to matters relevant lang do sa issue para for the speedy disposition of the case. Remember, so nandiyan si labor arbiter, siya ang magkocontrol ng case. So, magpipresent ang parties involved, the complainant and the respondent, allow the presentation of the evidence for cross-examination. Siya din ang maghihusga kung hanggang saan ang pwedeng i-present the evidence for the speedy disposition of the case. Now, class, do you have any questions? After that, the presentation of the case, he shall make a written summary of the proceedings. At saan? Ito ay pipirmahan ng parties involved that will form part of the official records. The parties and their counsels appearing before the labor arbiter shall be prepared for a continuous hearing or clarificatory conference. So, pinagbabawal ng postponement or continuance shall be allowed by the labor arbiter, except on meritorious grounds and subject to the requirement of expeditious disposition of the case. So, ma-determinate ang clarificatory hearing within 30 calendar days from the date of the initial clarificatory conference. So, in cases involving overseas, ay shall not exceed 60 days. Siyempre, ito ay gagaling pa sa ibang bansa, which will be required from the date of acquisition of jurisdiction by the labor arbiter over the person of the respondents. Now, what is the effect naman kapag non-appearance of the parties during clarificatory conference? So, di ba, mediation. Ngayon, sa clarificatory conference, pag hindi dumating during the hearing, despite due notice, proceedings shall be conducted ex parte. Thereafter, the case shall be deemed submitted for decision. So, magtutuloy pa rin yung proceedings hanggang makabuo ng decision. So, importante yon, submitted for decisions. Note niyan, ha? Next, what is the period within which to conduct pre-execution conference? So, within 2 working days from receipt from the motion of issuance of a writ of execution, accompanied by computation of judgment award if necessary, the commission of the arbiter may schedule a pre-execution conference to thresh out matters relevant to execution, including the final computation of monetary award. So, hindi siya mag-exceed ng 15 calendar days from initial schedule unless the parties agreed to an extension. Any order issued by the labor arbiter in the pre-execution conference is not appealable, subject to the remedies available under Rule XII or extraordinary remedies. So, pag sinabi ni labor arbiter, commission or the labor arbiter sa pre-execution, may 2 working days para makompute kung ano yung award na ibibigay. Next is, kung mayroon tayong kanina nabanggit ang labor arbiter, NLRC, ano naman ang jurisdiction ngayon ng NLRC? Meron silang 2 jurisdiction. Kung ang labor arbiter ay isa lang, ang NLRC ay meron. Kasi under ng NLRC, the umbrella nila ang labor arbiter. The NLRC had 2 kinds of jurisdiction, the original ones and the exclusive appellate jurisdiction, meaning, sino ba yung umaapela sa kanila sa NLRC? The original jurisdiction is injunction in ordinary labor disputes to enjoin or restrain any actual or threatened commission of any or all prohibited or unlawful acts or to require the performance of a particular act in any labor dispute, which, if not restrained or performed forthwith, may cause grave or irreparable damage to any party. So, injunction, yan, papasok sila. Mag-intervene sila para maiwasan yung damage to the parties involved. Kasama din siya yung kanilang injunction during strikes and lockouts. And of course, certified labor disputes causing or likely to cause a strike or lockout in an industry indispensable to the national interest, certified to it by the Secretary of Labor Employment for compulsory arbitration. They have also the exclusive appellate jurisdiction. All cases decided by the Labor Arbiters, including contempt cases, and of course cases decided by the DOLE regional directors or his duly authorized hearing officers under Article 129 involving recovery of wages, simple money claims, and other benefits not exceeding 5,000 and not accompanied by claim for the reinstatement. So going back, exclusive appellate. So, lahat ng kasong isasampa sa desisyon ng Labor Arbiter, including contempt cases. So, yan. Photographic memory activate. By the DOLE, yan. For reinstatement. What is the mode of appeal from the decision of the Labor Arbiters? The appeal is brought by ordinary appeal to the NLRC within 10 calendar days from the decision of the Labor Arbiter. From the decision of the NLRC, there is no appeal. The only way to elevate the case is to the Court of Appeals by virtue of civil action or the Rule 65 review certiorari. After that, di pa rin masiyahan sa Court of Appeals, they can elevate the matter sa kataas-taasang hukuman na tulad na nakikita nyo sa ating previous case analysis, the Rule 45 of the Rules of Civil Procedure. Yan, tatandaan ha. Yan. Photographic memory, activate. Now, what are the grounds for appeal? There are 4 grounds, and those are the following. If there is prima facie evidence of abuse of discretion on the part of the Labor Arbiter. So, at the first glance, makita prima facie is, at the first glance, may hindi napansin a Labor Arbiter or there has been a abuse or discretion on his part sa paggawa ng decision. If the decision or the award was secured through fraud or coercion, including graft and corruption. So, kung may naglagay. Now, if made purely on questions of law, that's third one. If serious errors in the findings of facts are raised which would cause grave or irreparable damage or injury to the appellant. So, may errors doon the findings on the jury sa umaapela. Next. After ma-establish kung ano ang errors committed by the Labor Arbiter, ano naman yung perfection of the appeal? First, it should be filed within the reglementary period provided in Section 1 of the Rule. 2. Verified by the appellant himself in accordance with Section 4, Rule 7 of the Rules of Court. So, there has to be a memorandum of appeal which shall state the grounds relied upon and arguments in support thereof. The relief prayed for and with a settlement of the date the appellant received the appeal decision, award, or order. So, kailangan tatlo siya. Tatlo yung memorandum of appeal na isasubmit, printed copies, and accompanied by proof of payment of the required appeal fee. So, may karampatang bayad, of course, and the legal research fee. Posting of a cash or surety bond is provided in Section 6 of this rule and proof of service upon the other parties. So, importante, may bayad ang pag-apila. Tatandaan. So, filed, reglementary, so within 10 calendar days. So, yan. Importante ito. Do you have any questions in mind? Let us now proceed with the periods of appeal. The decisions, awards, or orders of the Labor Arbiter shall be final and executory unless appealed to the Commission by 10 calendar days. Yan. Pursuant to Article 129 of the Labor Code, in 5 calendar days from receipt thereof. 5 days siya. RD. Now, if yung 10 at 5 ay mag-fall on Saturday, Sunday, holiday, ay shall be the first working day following such day. So, kapag kumatak siya holiday, Saturday, Sunday, mag-move siya ng 1 day. Papatak para dun sa araw na yun. Now, ano naman sinasabi ng reinstatement for the position based ng LA decision? If reinstatement is ordered by the Labor Arbiter in an illegal dismissal, it is immediately executory. Executory siya, even may pending appeal. Such award does not require a writ of execution. So, automatic yung reinstatement. So, we're through with NLRC, and we'll now proceed with the concentration for the Labor Arbiters. Before we going that, do you have any question?